Franchise marketing funds are a bit of a challenge for franchisees in particular. You will have noticed huge amounts of advertising by Harvey Norman, and Harvey Norman does operate through a franchise model. I'm going to race through this talk, and so this is basically the headings, and let's get going. Franchise relationships are pretty complicated. They're centered on conflicts of interest, and somehow the franchisor and the franchisee have to navigate these conflicts of interest. Basically, the franchise agreement gives the franchisor an unrestricted ability to exercise control, and the franchisor obviously drafts the agreement. Ultimately, the franchisee has to put up or go away, and there are significant issues giving the right opportunity for terrible opportunistic behaviour, in fact, by both parties. I'm just focusing on the marketing fund here because it's a fairly unexplored problem area of franchising, and as we see, it's pretty unresolved as well. So answers to questions like who controls the marketing fund, who spends it, who makes the decisions, should be quite clear, but they're far from clear. And it is justifiable in a way that the franchisor retains almost complete discretion, because they have to deal with situations like, how do we cope with COVID-19? How do we adjust our marketing to make sure that the franchisees and the brand survives a challenge like COVID-19? The purpose of marketing funds seems to be quite different for franchisors and for franchisees. So they see them as doing different things. The franchisor's role includes providing the marketing concept, product ideas and design, and it develops procedures for how to deliver the product and how to market it. So the purpose of the marketing fund is to allow the franchisor to get enough money to run their promotional and marketing activities. Now, this money usually comes from the franchisees, comes in two forms, and we'll see that in a minute. Aussie Farmers Direct is a great example that we will return to again. At the time Aussie Farmers Direct became insolvent, there was nearly $800,000 in the marketing fund. Aussie Farmers Direct franchisees receive certain promises in relation to how the marketing fund would be spent, but of course the franchise agreement being drafted by the franchisor doesn't really contain clear obligations about how to spend the money, who will spend it, and who will make the decisions. Franchisors are also required to provide marketing fund statements and an annual audit, but as we see from this comment by the franchisee, our marketing fund statements were impossible to make sense of, even if we saw the statements at all. But when done well, marketing fund expenditure does work. So reported in the paper a couple of weeks ago was that Harvey Norman's turnover has increased 17.1% during COVID-19. And I think we've all seen Harvey Norman's ads all over the newspaper and also on programs on TV like MasterChef. So they must be spending a truckload of money, but it seems to be delivering the right results. So we're just going to look through three lenses. Basically the contract, and I've already mentioned it. Franchise relationships are far too complex to reduce to precise statutory terms. So as Gillian Hadfield comments, the heart of franchising's legal structure is still the contract. And rather than spell out every single decision ex ante, the contract designs a decision-making structure, and it assigns to the franchisor responsibility for responding to market conditions, and the franchisee has to comply. And it'd be fair to say that very few contracts are called upon to accomplish so complex a task as to structure an entire 10 to 20 year relationship under conditions of significant uncertainty that we see more than ever in the COVID-19 retail market environment. So while roles and areas of responsibility are laid out, the court then receives little clear guidance from the contract when it's called upon to decide issues concerning the marketing fund. This has been observed in the US, and as we'll see in a moment, it's also problematic for Australian courts. So this is an example of the Michelle's Patisserie franchise obligation. The franchisor is obliged to administer the National Marketing Fund bank account in accordance with Clause 7. Clause 7 is very vague and basically says franchisor can do whatever they like in relation to marketing. Franchisees from 123 locations agree to contribute the greater of 3% of their gross sales, or $200 per week plus GST, to the fund, in addition to an initial marketing activity fee of $3,000. The franchisor has a discretion whether to contribute. So I've estimated that there'd be nearly $1.5 million per annum into that fund, all controlled by the franchisor. It doesn't end there. The Michelle's Fund is audited annually by PwC, but the audit fund report provided as part of the mandatory pre-contract and ongoing disclosure lumps all 7 of the retail food group brands together for the purposes of marketing. So pretty useless really when you're an individual franchisee trying to work out what your rights are. Consumer protection. The Parliament of South Australia conducted a review in 2008 and concluded that part of the attraction of the marketing model is that the franchisor's marketing efforts often stress the unimportance of previous experience in a way to attract franchisees in. And an example of this is seen in the Croissant Express franchise. The franchisees thought that $420,000 that was taken for a point of sale system was taken out of the marketing fund was actually supposed to be used to market their business. But there was no marketing done of any significance except in-store posters to existing customers. So as you can see, the franchisor and the franchisee had very different ideas about what marketing was and how the money could be spent. The Croissant Express does reveal a consumer protection challenge for regulators. They say that a moral hazard may emerge where consumers perceive there to be an implicit contract between themselves and the regulatory agency, in this case the ACCC. The Croissant Express submission to the franchise inquiry suggests that franchisees actually believed that the ACCC wouldn't fall for the franchisor's explanation about what they spent this money on and the value of a point of sale system and its correlation with marketing. The ACCC accepted the franchisor's explanation to the astonishment of the franchisees. Research that I've done with Uri Ben Alil certainly reveals that many franchisees are unrealistically over-optimistic about all sorts of things. There have been numerous, in fact 16 or 17 government-initiated franchise inquiries. In 2013, the ACCC reported that it had received 49 complaints in a 5-year period about how franchisors are spending their marketing funds. And Alan Wine, who conducted that inquiry, made the recommendation that contributions to marketing funds from individual franchisees should be held on trust for franchisees, with the franchisor to have wide discretion as to how to spend the money. Unfortunately, this is the only one of his marketing-related recommendations that the government did not accept. So there's a couple of provisions in the Franchising Code of Conduct, which I won't read, but they're just here for the sake of the record. The disclosure document, clause 15 and clause 31 of the code itself refer to marketing fund issues. Then we come to franchisor insolvency, which is a game changer. So the laws of contract and the consumer protection laws in Australia are trumped by the duties of insolvency practitioners and the rights of creditors under the Corporations Act. So the ACCC gets put to one side and enter ASIC. Transactional lawyers are seldom insolvency experts, and so they don't build in protections for franchisees, and they don't argue for protections for franchisees because they basically believe the rhetoric that franchisors are proven and don't fail. So in franchisor insolvency, we have a situation where the franchisee is best categorized as an externality. So what have the courts said about marketing funds? Well, not very much, to be honest. And Gillian Hadfield said where the courts go astray, and this was back in the 1990s in the US, it still applies today, is in treating the franchisor's interest as if it represented the entirety of the relationship. But one very important case has thrown light on the predicament that franchisees get into when a liquidator is appointed to their franchise. So in the matter of Stay in Bed Milk and Bread Proprietary Limited in liquidation, the liquidators sought guidance from the court, and the issue was, could the nearly $800,000 in the marketing fund be returned to the 91 franchisors whose money it initially was, or could the Commonwealth access it for the franchisor's 259 employees who were owed over $4 million in outstanding entitlements? Had Wine's recommendation been accepted, this would have been a no-brainer and it wouldn't have gone to court. But it did go to court, and the court found that the franchise agreement in this case, does not provide an express mechanism for the franchisor as purported trustee to distribute any beneficial interest that the franchisees might have, either to the franchisees as a class or individually. So the franchisor was given the right to accumulate the money. The liquidator posed the quist close trust argument in relation to, as well as another argument, neither of which flew. The quist close trust was an interesting argument, and it should have worked, I think. But since the decision of the House of Lords in quist close, it's been recognised that money paid for a specific purpose may be held on trust in circumstances where the purpose could no longer be carried out. So you'd have to imagine that maybe this was such a case. But the liquidators were up against the Commonwealth, and the Commonwealth replied by saying that in the absence of any documented mechanism for recording and quantifying the alleged beneficial interest of the franchisees, this tells against any mutual intention to hold monies on trust. So the Australian Government Department of Jobs and Small Business argued that no trust had been created, no quist close and no other kind of trust, and that the money should be an asset of the franchisor available to fund the shortfall of wages and entitlements owing to the employees and payable under the Fair Entitlements Guarantee Fund. The liquidators and thus the franchisees lost. The government and the former employees of this franchise were successful, and the costs had to be taken out of the marketing fund. As I said, had Alan Wine's recommendation been accepted, the money would have been held in trust. Okay, so I've got three possible solutions to this great big challenge. First of all, why on earth didn't the government adopt Alan Wine's suggestion? The reason they didn't adopt it appears to be that the franchisors lobbied pretty hard, and they made a lot of stupid suggestions, to be honest, and these suggestions just basically did not hold water if you put them up to scrutiny. They argued that requiring the marketing funds to be formally treated as trust funds would be problematic. Well, problematic for who? Problematic for the franchisor, because they couldn't demonstrate that they had all this money under their control, and they couldn't therefore demonstrate to, for example, a bank that they were more solvent than they actually were. They said that there would be additional compliance burdens associated with keeping a trust account that might deter franchisors from setting up marketing funds at all. Well, terribly sorry, guys, but the compliance burdens are always going to be there. So the third one is this could have an impact on taxation arrangements. One of my colleagues in the School of Taxation and Business Law said this actually could have a beneficial impact on the franchisor's taxation arrangements. So why wasn't that investigated a little bit more? This could impact the franchisor's creditworthiness and the cost of credit. Well, hello, guys. Are you running a solvent business or not? So basically, the government rejected Alan Wine's recommendation back there in 2014. I'm also really surprised that the liquidators didn't run an unjust enrichment argument. It is possible to argue that a huge range of stakeholders may be unjustly enriched by the marketing fund, but the stakeholders that are most unjustly enriched are the franchisors' creditors, particularly their unsecured creditors or their priority creditors like employees. Very difficult for franchisees to pursue the unjust enrichment avenue because of the various rules relating to prosecution during an insolvency. And I go into those much more in my paper. The Parliamentary Joint Committee on Corporations and Financial Services had a very big inquiry in 2018, and they reported in 2019 in a report to Fairness in Franchising. They again recommended that the government clarify through legislation the distribution of unused marketing funds in the event of the franchisor winding up. So that, my friends, is that, and thank you so much for listening to me.